or the community organizations that are doing good work in our communities. And of course, if we want to end violence and crime in the long term, we need to make the upstream investments in affordable housing and mental health and addictions and in programs that address at-risk youth. But today we're talking about that first pillar, stronger criminal laws. This is not the first piece of criminal legislation reform that you will have seen tabled in the House of Commons. We have seen different pieces of legislation to strengthen our borders, to amend the bail and sentencing regimes that exist in Canada, to combat hate crimes that take place in the country. And of course, today, with the tabling of the Protecting Victims Act, we have an opportunity to better protect kids who are at risk of exploitation, and to address very real concerns about violence against women, including violence that could be fatal. The first piece of the legislation that I'd like to draw into focus really touches on violence that we see that often plays out in an intimate partner violence context. You've heard multiple speakers share the statistic about a woman being killed in this country every other day. This is a statistic that should shock the conscience of every Canadian, not just because of the number of people who are impacted, but because we understand through our own experiences that these are real people in real communities. For some of us, that's the classmates that we grew up with, who we used to visit, who grew up down the street. For others, it is our co-workers who we no longer see at the office. And for others, it is the immediate family members whose life has been ended too soon. We're moving forward with changes that will recognize the severe impact that femicide has on families, on communities, on people in this country. We specifically will be creating a constructive first-degree murder charge where certain factors are present when a murder takes place, including a murder that is motivated by hate, including murder that takes place during the commission of a sexual offense, and including murder that follows a pattern of coercive and controlling behavior. I want to pause on this last point, because as you've heard, we've also made the decision to move forward with a standalone offense of coercive control. And in addition to the many advocates that you see here in our caucus, with community organizations and across the country, we owe a debt of gratitude to our former colleague in Parliament, Laurel Collins, who did incredible work in the last Parliament to advance this matter. And Laurel, if you're watching today, I want to say thank you and recognize your work in getting us to this piece of legislation. What's important when it comes to coercive control? We have an opportunity to have the justice system intervene, not just after someone has been killed, but we have an opportunity to have the justice system intervene before a relationship becomes violent and before violence becomes fatal. It is not enough to simply punish bad actors on the back end of a tragedy, but to do everything we can to prevent violence from taking place in the first instance. In addition to these changes that tackle matters of gender-based and intimate partner violence, there are new sexual offenses that have been established, including making good on the campaign commitment to criminalize the non-consensual distribution of intimate images, including specifically those that are created through the use of artificial intelligence. Il est essentiel pour lutter contre la violence et recogniser les changements technologiques qui existent.
And deal with the technological changes that exist now in our society. When people share images, it's a crime. But we need to change the rules to recognize. The law today does not include recognition of AI. For example.
It's essential in a world that we live in when we know we all walk around with phones in our pockets that are incredibly powerful, that create access to artificial intelligence, modern tools that certainly have benefits for society, that we recognize at the same time it creates potential for abuse. We are seeing a gap that exists in the criminal code, and we are fixing that today to ensure that artificial intelligence deepfakes will be recognized when it comes to charging people for the non-consensual disclosure of intimate images. Similarly, we'll be expanding the application of this particular provision to include circumstances not only where these images are distributed, but where their distribution is threatened to prevent that kind of sexual coercion from taking place in our communities. Along a similar line, it's essential that we adopt measures that better keep our children safe, who increasingly are growing up in an online environment in a world where the difference between the real world and online environments is indivisible. We are going to ensure that the threatening distribution of child sexual abuse and exploitation material is included to address challenges we see with sextortion in this country. We'll be establishing new offenses to better protect our kids, including inviting exposure of a child to an adult. and strengthening the ability of the Canadian justice system to respond to the abuse of children that may take place in another part of the world. It's important that we get these offences right, but we also have to have a discussion about what the appropriate penalties are. There's a series of sexual offences that will see higher maximum penalties as a result of this legislation. And at the same time, we will be following the guidance of the Supreme Court of Canada to restore mandatory minimum penalties in a way that is constitutionally compliant. This will have the impact not only of addressing the case that you will all be familiar with that recently came to light this fall in the Senville decision, which struck down the mandatory minimum penalty of 1 year for its unconstitutional status. But this should not come as a surprise. There are many instances where the Supreme Court of Canada has struck down similar penalties that existed in the criminal code. We're moving forward with a strategy that will not only restore those penalties that have been struck down, but that will protect the remaining mandatory minimums that have not yet been struck down, but which are constitutionally vulnerable. As we move forward, it's essential that we address some of the systemic challenges that are leading to cases being dismissed, not as a result of charges being defeated in a court, but as a result of delays. Les délais, c'est inacceptable. Ce n'est pas une bonne chose pour les victimes.
Delays are unacceptable. It's not good for victims, nor for society. We need to address these challenges in the legal system.
A number of years ago, we've seen through recent reports nearly 10,000 cases have been thrown out as a result of delays in the justice system. We want to address this problem in a few different ways. We will be advancing measures within federal jurisdiction to speed up the process of criminal justice in Canada, including in specific amendments that will have an impact on sexual assault trials in this country. In particular, we will be changing the regime on how evidence is adduced to streamline the process and shorten the time between a charge and the conclusion of a trial. In addition to these procedural changes that will reduce the number of cases that face lengthy delays, we will be addressing in the short term the phenomenon where cases are dismissed for delay, again, not because charges have been defeated, but because the process has taken too long. We intend to do this by specifically dealing with the way that time is calculated, by scoping out certain kinds of applications from the calculation of time, by better clarifying when a case is complex for the purpose of the definition in the Jordan decision to ensure that those which are likely to take longer, potentially including many sexual assault trials, will less often be tied to the lower temporal threshold set by the Supreme Court. And we will be asking the court specifically to consider remedies other than a stay of proceedings. Because I can tell you, it does not feel like justice to survivors of sexual violence when at the end of the process, there is no conviction and a perpetrator, despite not defeating the charges, continues to live in the same community and in some instances the same neighborhood as the victim. We'll be moving forward with certain amendments to the Victims' Bill of Rights as well to ensure that victims have a role to play, that they have information about where they can play a role, and that their voice will inform the judicial process when they're going through the criminal justice proceedings. There is much work ahead. The criminal justice reforms that we are putting on the table today are an important step in the right direction. But I would be remiss if I didn't recognize the extraordinary need to continue to support survivors in communities and the organizations that work with them to advocate for change and to provide meaningful supports. For too long, gender-based violence has been treated as a women's issue. We've been counting on survivors to be their own advocates and leaving the hard work to community organizations who work professionally in this space. Gender-based violence and the exploitation of Canadian children is an issue that should concern all of us. And I hope that you will take from today that the federal government is committed to being a good partner in this cause. And we look forward to receiving the support of all parties in the House of Commons to adopt this bill expeditiously. Thank you, and grand merci.
Thank you to both Ministers Fraser and Valdez. So now we will now move into the question and answer period. If you have your questions, I would invite you to come closer to the mic. And I think, Lola, you'll moderate.
Yes, yes. Hi, one question, one follow-up. Please state your name and outlet. Hi, Stephanie Taylor with the National Post. This question is for the minister. It's about Bill C9. I'd like to know why are government MPs going to be supporting the amendment from the Bloc to remove religious defences from the willful promotion of hate in the criminal code when the government has heard loudly from Muslim and Christian and other religious groups that this could insert uncertainty into their teaching and preachings of religious texts and potentially chill their speech?
Thank you. And look, I will address the question head on. I do think it's important that we reflect on the reason we're here today to address a piece of legislation targeting gender-based violence, but I appreciate there are multiple priorities, all of which are important. So let's be clear about what's being proposed and what's not. The amendment that the Bloc is proposing will, in my view, in no way, shape, or form prevent a religious leader from reading their religious texts. It will not criminalize faith, and to suggest otherwise, in my view, is a perversion of the values that the major religions in this country and around the world stand for. As somebody who grew up in the Catholic Church and read Scripture on Sundays my whole life, I can tell you that I don't remember any messages about religion telling you to hate thy neighbor. We are dealing with charges that touch on the willful promotion of hate. That is not a value that the world's major religions stand for, nor would I accept such a change. We've engaged with a number of parliamentary colleagues, including the Bloc members who are seeking to put forward this motion, including members of our own caucus, including on a number of occasions members of different party caucuses. What's important to recognize here is that it's a decision for the committee to determine whether this would go forward. My own role has been to engage with members of different parties to identify whether there is a path forward for the bill, keeping in mind from inception that the Combating Hate Act was actually designed to address discrimination initially against religious communities who are being prevented from taking part in their communities of faith by virtue of attending their religious institutions, places of worship, or community centers designed for specific communities. My view is that we're entertaining different perspectives to figure out what path forward would allow us to make good on the campaign commitment we've made to those communities and to address combating hate more broadly. If we thought there would be amendments that would make it impossible for people to practice their religion, we wouldn't support them. That would be antithetical to the very purpose of the bill. Should there be an opportunity to protect the bill and see its rapid adoption into Canadian law, we'll entertain potential amendments, but this is going to be a decision that members of the committee take.
When it comes specifically to your role